Have you recently heard that the UK is changing its immigration system? And suddenly everyone online seems to have a different version of the story? Some say the UK will make migrants wait 10 years for settlement. Others claim you might need 15 years if you're a care worker. Then there are posts saying you can pay your way to permanent residency, or that existing years in the UK will automatically count toward the new rules. But here's the problem. Right now, the biggest challenge in UK immigration isn't just the policy changes themselves. The real challenge is figuring out what's actually confirmed, what's credible reporting, and what's pure rumor spreading across social media. And when people are making life-changing decisions about their careers, families, and futures, relying on the wrong information can be extremely dangerous. So in today's video, we're going to break everything down clearly. We'll look at what changes are officially confirmed, what information comes from credible government statements but isn't yet written into law, what details are reported by experts but still unconfirmed, and which claims are complete speculation with no real evidence behind them. By the end of this video, you'll understand exactly what's real, what might happen, and what you should completely ignore when planning your future in the UK. Welcome back to GoUKGo, the channel where we break down major global policy changes, immigration updates, and opportunities so you can make smarter decisions about your future. Let's start with the most important category, the changes that are already confirmed and implemented. These are not rumors. These are not predictions. These are actual policies already published and in effect. The first major change came into force on March 1st, 2026. The UK government introduced a new system for asylum seekers called 30-month temporary refugee protection. Previously, refugees who were granted asylum in the UK typically received 5 years of protection, after which they could apply for settlement. But under the new system, refugees will now receive only 30 months of protection initially. After those 30 months, their status will be reviewed by the Home Office. During that review, the government will assess whether the person's home country has become safe enough for them to return. If officials believe the country is now safe, the individual could face deportation back to their home country. This policy change is not speculation. It was published in the official Statement of Changes in Immigration Rules and is already in force. Anyone granted asylum in the UK after March 1st, 2026 is now subject to this system. The second confirmed change came just a few days later. On March 5th, 2026, the UK government suspended study visas for nationals from 4 countries. Those countries are Afghanistan, Cameroon, Myanmar, and Sudan. In addition, Afghanistan also lost access to the skilled worker visa route. This decision was also published in the official immigration rule changes. The Home Office justified the policy by pointing to data showing that 95% of Afghan nationals who entered the UK on student visas since 2021 later applied for asylum. In the case of Myanmar, asylum claims from students had increased 16 times compared to previous years. According to the government, this pattern represented system abuse, where people were entering through study routes but ultimately using them as pathways to asylum. So the UK decided to restrict these visa routes for those specific countries. Again, these changes are confirmed law. They're already implemented, publicly documented, and can be verified directly on gov.uk. Now let's move to the second category. These are changes that are confirmed by the government, but not yet officially written into the immigration rules. This category is where most of the confusion online comes from. Because the information is credible, but technically not finalized yet. One of the biggest announcements came from UK Home Secretary Shabana Mahmood. In several interviews and public statements in early March, she confirmed that the government plans to introduce a new 10-year pathway to indefinite leave to remain, also known as ILR. Currently, many visa routes allow migrants to apply for settlement after 5 years of continuous residence. But under the proposed system, the baseline would be 10 years instead of 5. What makes this proposal even more controversial is that the government intends to apply it retrospectively. That means the rule would affect people already living in the UK who have not yet obtained settlement status. The expected timeline for implementation is autumn 2026. That means the new system could start sometime between September and November 2026. But here's where it gets even more complex. Different categories of workers may face different timelines. For example, care workers could face a much longer pathway. Under the proposals discussed by the Home Secretary, care workers may need to wait 15 years instead of 10 years before becoming eligible for settlement. At the same time, the government is considering faster settlement options for high earners. Individuals earning more than £125,000 per year could potentially qualify for settlement after just 3 years. The new system would also introduce something called earned settlement. Instead of simply waiting a fixed number of years, migrants might need to demonstrate contributions to the UK. These contributions could include paying taxes and contributing economically, maintaining a clean immigration record, participating in community or social engagement, demonstrating positive integration into society. All of this information comes from direct statements made by the Home Secretary, reported by major outlets such as BBC, Bloomberg, and The Times. So it's not rumor. It represents the official direction of government policy. However, because these proposals have not yet been published in the official immigration rule changes, there is still a possibility that details could change before implementation. The timelines might be adjusted, additional protections might be added, or some rules might be modified before they become law. This is why experts classify these policies as confirmed government position, but not yet finalized legislation. Now let's move to the third category, information that is credible but still unconfirmed. This includes reports and interpretations from immigration lawyers, policy analysts, and journalists, but which have not been directly confirmed by the government. A good example is the possible cutoff date of September 1st, 2026. Many immigration commentators believe this could be the date when the new 10-year ILR rule takes effect. The reasoning is simple. The Home Secretary said the changes will begin in autumn 2026, and in the UK, autumn officially begins on September 1st. So many experts assume that could be the starting date. However, autumn technically runs from September through November. That means the government could also choose October 1st or November 1st instead. Until the official rule changes are published, the exact date remains uncertain. Another idea circulating among experts involves household income assessments. Some policy analysts believe the government may evaluate the combined income of families when determining eligibility for faster settlement. For example, if one partner earns £80,000 and the other earns £40,000, their combined household income would be £120,000. In theory, that household might qualify for benefits similar to a single high earner. This concept appears in policy discussions and Migration Advisory Committee reports, and it exists in countries like Denmark. But again, the UK government has not officially confirmed it. There are also discussions about sector-specific bonuses. Some experts believe professions facing severe shortages, such as nurses and teachers, might receive extra credits towards settlement. For example, a nurse earning £40,000 might receive additional points recognizing the importance of healthcare workers. But while this idea makes policy sense, it remains speculation until officially confirmed. Finally, we reach the last category, pure rumors. These are claims circulating online without any credible source or official confirmation. One common rumor suggests that migrants who have already lived in the UK for several years will automatically receive credit toward the new 10-year rule. For example, someone who has already lived in the UK for 3 years might believe they only need 7 more years to qualify. But based on government statements, this interpretation is incorrect. If the rule is implemented retrospectively, the 10-year clock could restart from the implementation date, not from the original arrival date. That means someone who has already lived in the UK for 4 years might still face another full 10-year period before settlement. Another rumor claims migrants might be able to pay large sums of money to skip the waiting period. Some posts online even mention figures like £50,000 buyout options for immediate residency. There is absolutely no evidence supporting this claim. No government proposal, consultation document, or credible journalist has reported anything like it. It appears to be completely fabricated. And the reason these rumors spread so quickly is simple. When people are facing uncertainty and long waiting periods, they naturally want to believe there might be an easier solution. But believing in false information can lead to very dangerous decisions. So how can you protect yourself? How can you verify which information is actually real? The first step is always to check gov.uk. The UK government publishes official immigration rule changes in documents called Statements of Changes in Immigration Rules. If a policy appears there with an effective date, it is confirmed law. If it doesn't appear there yet, it has not been implemented. Second, review official government speeches and press releases. If a minister announces something in an official statement published by the Home Office, it reflects the government's official position. Third, rely on credible news organizations. Major outlets like BBC, Bloomberg, and the Financial Times typically verify their information with government sources before publishing. Fourth, consult registered immigration lawyers or regulated advisors. These professionals often receive official guidance and updates that may not yet be widely public. Finally, review reports from the Migration Advisory Committee, which provides policy analysis and recommendations to the government. These reports often reveal which policies are being seriously considered. So what should you actually do while waiting for final clarity? If you are approaching eligibility for 5-year settlement before autumn 2026, it may be wise to submit your ILR application as soon as possible. Even if the exact cutoff date is uncertain, applying earlier increases your chances of qualifying under the current rules. If you are not eligible until after the changes take effect, you may need to start preparing for an earned settlement system. That could include maximizing your economic contributions, maintaining a strong employment record, and ensuring perfect immigration compliance. For those considering moving to the UK in the future, it's important to recognize that immigration pathways may become longer and more complex. And for migrants already living in the UK, the decision of whether to stay long-term may depend on how these policies ultimately evolve. Interestingly, these proposals have also created political tension within the UK government itself. More than 100 members of parliament from the ruling Labour Party have reportedly expressed concerns about applying the new rules retrospectively. Some MPs argue that changing settlement rules for people who already moved to the UK under different expectations could be unfair. However, the government still holds a large parliamentary majority, which means the policies could still pass even if some lawmakers oppose them. Whether these concerns lead to changes or transitional protections remains to be seen. For now, the most important thing to remember is this: some immigration changes are already law. Some are confirmed government plans that haven't yet been finalized. Some are credible predictions based on policy discussions. And some are simply rumors spreading across the internet. Understanding the difference between these categories is absolutely critical if you are planning your future in the UK. And that's exactly why we break down complex global policy changes here on GoUKGo. If this video helped you understand the situation more clearly, make sure to like the video so more people can see accurate information instead of rumors. Subscribe to GoUKGo because as soon as the UK government publishes the final immigration rule changes, we'll break down every detail and explain exactly what it means for workers, students, and families. And if you've heard any immigration rumors that you're unsure about, drop them in the comments. We'll investigate them and separate the facts from the speculation in future videos. Because when it comes to immigration policy, accurate information isn't just helpful, it's essential for making life-changing decisions. Thanks for watching GoUKGo, and I'll see you in the next video.